right, good evening, everyone. My name is James, Executive Director here at Present Pillars. I have with me today Blair Johnson of Blair. Tell me your firm's name again.
Blair Law.
Blair Law. And today we'll be kicking off our series, Due Process for Dads, with Blair, talking about expungement. So we want to just let you know you can leave comments in any of our chats, any of our platforms, I should say. Leave your questions in the comments, and we'll be able to answer those towards the end. And hopefully they get answered throughout the presentation. So we don't want to hold you all night, so I'll go ahead and let Blair get started.
Thanks, James. All right. I gotta get me. There we go. All right. Good evening, everybody. My name is Blair Johnson. I'm an attorney, solo practice here in St. Joe. Blair Law is my practice. A little background on me. I was born and raised here in St. Joe. Went to Hope College, got my undergrad in English and creative writing. Came back and worked for my father, who's been practicing law here for over 50 years now. He did a lot of practice, some of which I do now, but I got drawn to Social Security disability, like helping people get their disability benefits, working through that system, and felt comfortable enough to take the LSAT, go to law school. I went to Indiana University, Bloomington, and I've been practicing law in St. Joe here in Berrien County for 10, 11 years. And I've just gotten to know James in the last few months, actually heard about him through several different people at Berrien County Courthouse. Said he was doing really good stuff here with Present Pillars. Our circles came together, and I'm really excited to launch this series here. I said, what can I do to help? It's really been my approach with being an attorney is I really want to help folks understand the law, empower them so they can make informed decisions, challenge them and support them, because it is long, it is difficult, it is confusing, and so he said, well, what about a series of this? We're going to be doing a series, and we'll talk about the upcoming events over the next few months at the end of tonight's session. But tonight we're going to talk about expungement. Worked with James and with West Michigan Legal Aid on earlier this summer. We did an expungement clinic here at the Pillar Center, and I understand there's also going to be a fair at LMC, and we'll talk about that at the end. And I will do my best to be there to help that event as well. So, because we're calling this Due Process for Dads, it's an Ask a Lawyer, frequently asked questions session. I wanted to lead, as I always like to do, with what's the history in this area. So the history of Michigan expungement law was pretty bad for a very long time. The law, as you can see on the screen, it's actually Michigan Comprehensive Law at 780.621, was first passed in 1965, and for almost 50 years, all you could have set aside or expunged was one misdemeanor conviction. Didn't really help a lot of folks. So in 2011, they added one misdemeanor, which is up to a year, and over a year is a felony, and two minor misdemeanors, which are less than 93 days. And that's the maximum penalty that you can serve. We didn't really do much for folks. In 2014, they gave the option. You could either have expunged one felony or two misdemeanor convictions. That was a step forward because felonies had been excluded for the previous few years. However, not a whole lot that could be done. They expanded that allowance in 2016, and then really exciting that in October of 2020, bipartisan effort with a Democratic governor and a Republican legislature here in Michigan passed the Clean Slate Act, and that Clean Slate Act really blew the doors open and allowed for up to 3 felonies and an unlimited number of misdemeanor convictions to be set aside. On the timeline, I didn't include that. Made a slight adjustment in 22 and added one DUI offense. So only one drunk driving offense could be set aside. Previously, none could be set aside. And most recently, in the last 18 months or so, automatic set aside for up to 2 felony and 4 misdemeanor convictions rolled out. And I'll talk about automatic set aside at the end of this session. So for those of us who've been working in this area for a long time, clean slate, I mean, it revolutionized, and made it possible for so many people to finally get free of, mostly it was the felonies that were holding them back from being able to get housing, jobs, to get loans. I mean, any number of things that we all knew that these third parties weren't really interested in misdemeanors. They were concerned about the felonies. So it's been really an exciting time for the last 4 years to be helping people in this area of the law. So what isn't eligible? And I guess I should say first, what does it mean, for expungement or conviction set aside? So the legal terminology is to have your conviction set aside. People call it expungement. What it really is it's sealed. So I'll talk about it at the end, but your conviction is sealed from public record, but still available on a limited basis. So it doesn't get removed and erased completely, but it's set aside for purposes of you're living your life in the public sphere. So what isn't eligible under the Clean Slate Act is a felony that has a maximum punishment of life in prison. Certain child abuse and sexual misconduct offenses, CSC offenses, are not eligible for set aside. Felony conviction for domestic violence, any traffic offense involving commercial driving, driver's license, any traffic offense, involving injury or death, more than one drunk driving, more than 2 assaultive offenses, and any offenses all offenses are excluded if the applicant has more than 3 felonies. So if a person has 4 felonies and a certain number of misdemeanors, nothing can be expunged at all. When are you eligible? So the time periods under Clean Slate. The thing to keep in mind is the date of your last contact with the justice system. What that means is the date of the last of the following. Either your imposition of sentence, when you were sentenced by the court, your release from jail or prison, or your release from probation or parole. So think of it as the last time that you had to report to anybody for a criminal conviction that you're seeking to have set aside. So from that date, you would then add 7 years if you have more than 1 felony conviction. From that date, you would add 5 years for just 1 felony conviction or 1 or more serious misdemeanor convictions. And I'll talk about what those are a little bit later. And then 3 years from the date of, from the last date of contact for 1 or more misdemeanor convictions. One thing to point out here is what is a felony and a misdemeanor under set-aside law purposes is determined by the maximum length of sentence. Some of you may be familiar with the term high court misdemeanor. A high court misdemeanor typically carries a 2-year maximum penalty, but they classify it as a misdemeanor. For purposes of set-aside, because that high court misdemeanor has a 2-year maximum penalty, it is considered a felony for set-aside purposes. So you would be subject to the 5-year or 7-year wait periods, depending on how many felonies are on your record. And note at the bottom too, in order to be eligible, all fines and costs and restitution must be paid in full. So if there are fines and costs still outstanding, even if the conviction was 20-some years ago, the court is going to require that those be satisfied in full before you may submit your application to set aside a conviction. So what is a serious misdemeanor? Any number of offenses that include certain assaultive offenses, domestic violence, resisting and obstructing, breaking and entering, fourth degree child abuse, some firearms, discharge of firearms offenses, stalking, indecent exposure, use of internet to make a prohibited communication, contributing to the delinquency of a minor, reduced conviction for any of the above. In other words, if you had you were charged with something that was a domestic violence, but it was pled down, and then an OWI or impaired driving offense, that first offense. So all of those offenses are considered serious and require that 5-year waiting period rather than the 3-year waiting period. A few other things to point out under clean slate. One it's been known as, one provision is known as the one bad night rule. So if you have one bad night where you commit a number of offenses within a 24-hour period, the court has, under certain conditions, the ability to consider that as one transaction, meaning that even though you may have multiple convictions that would stack together, disqualify you from set aside or require a longer waiting period, if they fall within this 24-hour transactional period, you can qualify under that one bad night rule. Now, as I've said here, I don't think I have it in here what those provisions are. There are certain things, again, if the penalty is more than 10 years, that won't qualify under the one bad night rule. Other elements under clean slate, the expedited expungement of misdemeanor marijuana offenses. So when they passed this law, it was after the decriminalization of marijuana in Michigan. They wiped out or made it faster at the time, made it easier for you to apply to have your misdemeanor, that's use or possession of marijuana offenses, set aside without having a hearing. Now, that was when this rolled out in April of 2021. My best guess is that most of these use and possession marijuana offenses should now have been set aside under the automatic set aside. There is expedited procedure if you still have a use or possession of marijuana on your record that will avoid needing to have a hearing. It speeds up the process, saves you 3 to 5 months. And then finally, the automatic expungement rolled out in April of 2023. Again, allows for up to 2 felony and misdemeanor offenses to be set aside. I just have it at the bottom there what the exclusions are for the one bad night rule. So moving on. So how do you apply? The first step is you've got to be fingerprinted. Easiest place to do it is to do it at your local sheriff's department or police station. It's got to be done on the card. Michigan is still not set up for live scan printing for submitting these applications. So you've got to go and get the RIO-08 is the Michigan card. For those folks who may be tuning in from out of state, and you need to have a Michigan conviction set aside, there is the federal FBI fingerprint card that is accepted. The acronym escapes me right now. But if because the RIO-08, the Michigan card is only available in Michigan, so you don't need to come to Michigan to be fingerprinted. You can use the federal fingerprint card and have that done where you live and send that in with your application. First thing is fingerprints. Second is you need to get certified judgments of all the sentences for your convictions from the county clerk. So those are typically $11 a piece, $10 for the record, $1 certify. I'm sorry, $1 for the record, $10 to certify. But those have to be attached. For every conviction that you want to have set aside, those need to be attached to your application. Then there's the application, which I'll show you in a second. You have to fill that out completely and sign it before a notary public. Then you file the application in the county where the conviction was entered, along with the judgments of sentence, and submit a copy to the county prosecutor, Michigan Attorney General, and Michigan State Police. The state police get the fingerprint card to run the background check. The state police will then run a federal FBI and Michigan State Police background check on you, send the results to you, and send the results to the court to verify what is in fact on your record, both in Michigan and nationwide. The Attorney General will also issue an opinion on whether or not it believes that you are eligible and qualify under the law to have any of your convictions set aside. Usually, that letter is a form letter that'll say simply, this person appears to qualify, and the court can make a decision under the law whether or not, as I've said the language here below, whether the post-conviction circumstances for the applicant warrant setting aside the conviction, and that setting aside the conviction is consistent with the public welfare. So after everything's been submitted, everything's been received, that hearing that's held, and I'll talk about that, that's where the court makes these legal determinations under the statute in terms of whether you qualify. Have your post-conviction circumstances shown that it's justifiable, you stayed out of trouble, maybe you're doing some good things, and that it would be in the interests of the general public welfare to do that. I'll explain what those terms mean. So here's the application. It's a 2-page application. It's available on online. MichiganLegalHelp.org has got these forms. The Self-Help Legal Center here in Berrien County at the courthouse has these available. It's a form produced by the Michigan State Court Administrator's Office. You're just filling in the blanks, and then at the very bottom, you're signing in front of the public notary. You have to disclose whether or not you've tried to have any of these convictions set aside, and whether or not any other convictions have been set aside. And then the last page is the notice of hearing and proof of service, which also is submitted to the court. The court will give you a hearing date for your application, as well as you would complete the proof of service saying when you mailed the forms and the fingerprint card to the Attorney General, County Prosecutor, and the Michigan State Police. Moving on here. So how much does this cost? First, there's no filing fee. It is free to file this with the court. There is, I think it's $13, could be $13, $14, to be fingerprinted. It's $11 per certified record to the county court, and then it's a $50 check to the Michigan State Police to run the background check. A couple things to point out here. So number one, if you have multiple convictions in the same county, you can list all of those convictions on one application. If I go back to this form here, you'll see that there are several line items there. And I've had applications that I've submitted where we have an addendum listing more as an attachment. As long as it's all within the same county, they can all be listed on one application. Now, if you have convictions in multiple counties, then you're going to have to submit a separate application in each county where those convictions were entered, along with a new set of fingerprints and the processing fee. So that can be where it gets a little bit expensive. If everything is located where a lot of my folks are in Berrien County, then it's simply $11 per page, $13 for the fingerprint, $50 to the state of Michigan, run those fingerprints and produce the report. So what happens at the hearing? And there's a question here about, is it okay to share this? However you can share it. I want to share it. I want to, when we get done with this, if there's a way to get everybody's email addresses, we're going to have this up. I'll distribute the PDFs for this PowerPoint, however I can do it, so that you can have this information, because I know I'm going to be throwing a lot of stuff at you in a short period of time. So however I can get it to you, I absolutely will. I want you to have it. So what happens at the hearing? First, and I guess I didn't put this in, I should say, these can be done on Zoom. I have been doing a number of these. I mean, when this rolled out in 2020, obviously it was COVID, so everything was happening. And even now, 4 years later, most of the courts that I've done this with, as long as there's a reasonable request made, usually somebody can't miss work or they live too far away. Most of the judges that I've been in front of have approved a request to do this on Zoom. If you want to appear in person or have to appear in person, obviously you got to come to court. Come to court, and the court will always confirm that everything filed in order. Got to make sure they have the results back from the state police. got to have the result back or the opinion back from the Attorney General. Once they've done that, they'll inquire whether the prosecuting attorney has any position on the application. The prosecuting attorney is standing in for the Michigan Attorney General. Typically, in my experience, they just follow what the Attorney General has said. I always check in as an attorney before I start a hearing with the prosecuting attorney who's handling the case that day, whether or not they have any issue. If I can address it beforehand, before we go on the record, I want to do that with my client. The court will then make an inquiry of you as the applicant. What happened at the time of the offenses? They want to know, what was going on in your life, what you did. Doesn't have to be a lot of detail. Practice tip number one is be honest. Don't argue about what you did back then. You pled guilty, you were found guilty. I can tell you, I've done, since Clean Slate, I think I've probably done 80 or so of these. The only one that I have lost is because my client minimized or argued that what she was convicted of 10 years earlier was not really true. And there's no point, doesn't do any good to own it. I tell all my clients, just own it, admit to it. You're wrong. You've already done the time. You've already paid the costs. It's only going to hurt you to argue about, whether the attorney didn't do right by you, or the police officer lied. It just doesn't help. Don't go there. The court will then inquire what you've been up to since the last time you were in trouble. Talk about your family, talk about your job, talk about any way you tried to better yourself, involved in church, highlight all the positive. One judge who loves to say, what do you do, for community service? It's required. A lot of my clients, they're just living their life. They stay out of trouble. Will it help? Yeah, certainly. But really, they're looking at, what have you done to make sure that you are not the same person back when you committed these crimes that you are today. That's the whole idea, is to give you a fresh start. So what have you been doing that shows you deserve that start? If you have a drug or alcohol issue, have you been in recovery or treatment? How's that going? That sort of thing. Then the court will, and so that's that post-conviction circumstances piece of the law. The second piece is it in the interest of the public welfare? The court's going to want to know why you're asking to have it set aside today. And I can tell you the number one reason why most people come to see me is that they want to get their gun rights restored. And that's perfectly fine, perfectly understandable, perfectly legal. And just be transparent about that. I have a lot of clients I've helped who are in their 60s and 70s, and they're really scared. But because they committed a felony back in their teens, 20s, or 30s, they cannot legally own a firearm. So it's not a bad thing if one of your reasons is, you want to protect yourself, or you want to hunt. It's also legit. Other people, it's clearing the conscience, bucket list. It's being able to tell my kids, this is who I am, how you've always known me to be, now what my record is. So it's a personal matter. For others, it's literally, I can't get a job or I can't move up in my life because this is holding me back. I will go through these questions towards the end of this thing and pull them in. So keep firing away. And I'm sure if James catches me with something, I'll jump in and answer that question right away. Now, the final piece is the court is going to let you know that day. I mean, they're going to tell you whether it's a thumbs up or a thumbs down. I haven't had a court not do that. I did have one where the judge wanted a little bit more. We had to go and do an evaluation for my client based on what he was asking to have to decide. But when finally they're going to do that day, it's done. And the outcome was. I was going to say something else about that. I've just forgotten. It'll come back to me. The whole process, it depends on the court. It depends on how it's run. But the hearing itself shouldn't take more than minutes. Sometimes it takes 5 minutes. What I do with my clients is before we have a hearing, I prepare a memo, and I send that to the court to get a little background on the points here. Because I really want to minimize what my client has to say to the judge. Not that they're going to do anything wrong, but I don't have any control over what's going to come out of their mouth. And so I try to give as much good information in advance to try to minimize that conversation in court. But a judge may want to hear it straight from you. Totally fine, totally right. I will say this, it just came to me. So if you saw that language, post-conviction circumstances, whether it warrants setting this conviction aside, and whether or not it's in the public interest welfare, it's very vague, it's very broad, it's very, there's a lot of judicial discretion. So there's really no way to appeal it, because a judge can decide, and give the reason that he or she thinks is valid, but there's no bullet points, there isn't any way to measure it. It's just a thumbs up or a thumbs down. Now, if you are not successful, you can apply again in 3 years to have that conviction set aside. So it's not that it's a one and done and you can never come back. But I try, my best to make it that first shot, because that's really when, again, what's going to change in 3 years, really. Now what happens after the hearing, is that the court will send a copy of the order to the arresting agency, the local department, as well as the state police. State police are required under the law to maintain a non-public record of the conviction that's available only to the court, state agencies, the Department of Corrections, prosecutor, attorney general, governor, on a limited basis, simply to determine whether or not you would qualify for a licensing. So, for example, somebody has been convicted of child abuse and set aside, that may not satisfy the Department of Health and Services granting this person a daycare license or a liquor license. Now, DHS have their own set-aside process that's separate from this. So you can get a daycare license if you've had those kinds of convictions. That's an independent process in this process we're talking about today. They can verify that a prior set-aside application has been filed, and then considering, at a later sentence, it is and can be treated as a prior conviction. So even though it can't be used against you out there in the public sphere when you're applying for jobs and things like that, again, because the court, the prosecuting attorney can see it on the inside, they could consider that as a conviction and as a sentence enhancement if you commit a subsequent offense. And then also for areas, if you're going to get a job with law enforcement or MDOC, they're going to need to see this and determining whether or not you have violated the Michigan Sex Offender Registration Act, which is SORA. And then finally, at the end of all that, you will receive a copy of the order in the mail. You can put it in a frame, put it on your headboard, whatever you want to do with it. But I'll tell you how long it takes here shortly to get that done. But the hearing is really the end of the process. Everything, closing out happens internally. So in terms of the length of time it takes, usually it takes my clients a couple of weeks to get fingerprints. These days, I think they're all requiring an appointment, so you call in advance. You can go get it done, pay the fee in, like I said, 1 to 2 weeks. Getting copies from the court, a couple of days. You can go over there and request the copies. The Self-Help Legal Center here, if you're in Berrien County, is terrific. They can look up your criminal background and see what your case numbers are so that you can go and ask for those records at the county clerk's office, in district or circuit court. A day to complete the application, take it to a notary, sign it, send out the copies. It takes, and I could say these have really picked up, these remaining ones. The rollout in April of 2021, the system was just jammed up. There were so many people who were applying that couldn't apply before, right? So there was just a bottleneck. But now I'd say in the last year or so, what I've been seeing is that it takes 4 to 5 weeks once the state police receive a report to your fingerprints to send you the report, the results. It'll take a couple of months for the attorney general to issue their letter. Comes to you and comes to the court. And then you can simply call the court and get a hearing date as soon as you get that letter in. And typically they schedule that hearing out 1 to 2 months from when you ask for it. And then being told by the expunction unit at the Michigan State Police, they recommend wait 6 to 8 weeks for the order setting aside conviction to process, to hit the books, so that if you were going to go and apply, to purchase a firearm or get a job and somebody were to do a background check on you, they recommend waiting 6 to 8 weeks. I can tell you, I've had clients who called me within 3 or 4 weeks after we finished the hearing, and they've gone and done one of those things and have not had an issue. So it really is, it really is just a matter of how long it takes the state police. But they say wait a couple of months before relying that record has officially been sealed or expunged. So overall, start to finish, the process is usually taking 6 to 8 months. Can take a little bit less, a little bit more, depending on your circumstances. Some courts, like Berrien County, will schedule the hearing. Not like Berrien County. Some courts will schedule the hearing in advance. Berrien County will not. They will wait until all of the reports have been received. That's because in the beginning, we were running into an issue where they would schedule a hearing, we get to the hearing date, but the state police report hadn't arrived, the attorney general's report hadn't arrived, and so they were adjourning it. I'm not seeing that issue anymore, but for the time being, I think the Berrien County process is still, wait until the information has all been received in court, and they will schedule the hearing date, let you know what it is. So what is automatic set-aside? So automatic set-aside rolled out a little less than a year and a half ago, starting in April 23. Up to 2 felony offenses and 4 misdemeanor offenses can be automatically set aside without you having to file an application. Now, the waiting periods for automatic set-aside are longer than the application waiting periods. Again, from that date of last contact with the court system, for a felony conviction, you got to wait 10 years. Under the application side, you wait 7 years. For any misdemeanor, any qualified misdemeanor convictions, you have to wait 7 years, whereas under the application side, you can apply after 3 years for non-serious, 5 years for serious. So you have the option, some of these, to either wait it out and let it fall off, or moving it up as long as you've qualified under the application statute, going ahead under the applicable time periods and filing an application to move it forward. In order to qualify under auto set-aside, that period, waiting period has to have expired. You can't have any criminal convictions in the intervening period, so you got to be staying out of trouble, and you cannot have any pending criminal charges against you. Some of these convictions are not eligible and have to be done with an application. In addition to the list that are never eligible that I said at the beginning, automatic set-aside does not apply to assaultive crimes, domestic violence, resisting, obstructing, crimes of dishonesty or fraud, writing a check, retail fraud, welfare fraud, those sorts of things. Serious misdemeanors that was earlier, human trafficking offenses with a maximum sentence of 10 years or more in prison. Because of the nature of those offenses, the court insists upon having a hearing and seeing your record and doing that whole formal process. The other caveat there that if you have more than one assault crime conviction, then you cannot have any conviction set aside. So if you've got a DV on your record, but you want to get these other ones off automatically, because of the DV, you're going to have to apply to have them all off. And at the bottom here, I mentioned again, as I said earlier, the decriminalization of marijuana offenses, I think, is vacated most possession or use at this point. But again, you can always, file an application under the application part of the statute. So what does it mean if you have your conviction set aside? You are no longer convicted, quote unquote, of the crime you previously committed under Michigan law. So for the most common way to think about this, I always tell my clients, is pay attention to the language. If you're going to fill out an application, Some of the applications may say, have you ever been convicted of a crime? You can answer no, because you have not, under Michigan law, you have not been convicted. If they say something like, have you ever been convicted of a crime, including any convictions that were set aside, then you have the quandary. So if they specifically ask for that, you're required to disclose it, or if they find out about it, then you can pretty much consider yourself toast. You're not going to get whatever you're asking for. Again, that non-public record is maintained on a limited basis for limited persons. Convictions do not come off your Michigan driving record. So if you lost your driving license for DUIs, you can have one DUI removed. You can't have more than one. You can have one. If you want to get one and be left with one, that's fine. But any DUI conviction that comes off your Michigan record does not come off your driving record. The driving record is really more for personal safety, not criminal record keeping. Conviction set aside also does not remove your requirement to register under SORA, the Michigan Sex Offender Registration Act. It does not affect the rights of a victim to seek relief for damages in civil court if there was damages that were sought. You're not entitled to get your money back for fines and costs that you paid just because your conviction was set aside. The conviction can't be used as evidence in an action for negligent hiring, admission, or licensure, meaning a employer licensing agency can't use this conviction against you to deny you the right for relief in whatever that job application is. And as I said before, it may, it's discretional, it may be used as a prior conviction in a subsequent criminal proceeding. So I think I've covered everything on my slide. Man, I nailed it. I get to 6 votes. We had 20 minutes for questions. All right, so okay, names are going to run off to me.
So it looks like we have a question here from Nicholas. He wants to know what our business email is. Nicholas, I will send that to you directly, but I also put it in the chat here. It's info@presentpillars.org. See, there was another question about what the date and time was for the expungement fair. Let's see. Can we share? So we didn't get any specific questions, but one question that I think would be great to ask, if you could just give us a quick recap of what things are absolutely not expungable, because that's the question I hear a lot.
Sure.
What is absolutely not expungable?
So we go back to what isn't expungible? Any felony that carries a maximum term of life imprisonment. It's too much. Certain child abuse and sexual misconduct offenses, but I can tell you, I got my phone here. Certainly, I got a cheat sheet that I can add to the materials at the end of the circulated form. But for CSD offenses, pretty much all of them. Attempted violation of first or second degree child abuse, violation or attempted violation of child abuse in the presence of another child, more than one DUI, felony domestic violence, human trafficking, any traffic offense where you are operating with your CDL license, a traffic offense that results in injury or death, CSC second, first, third conviction or fourth after January of 2015 cannot be set aside. This was a trade-off when they revised the Michigan Sex Offender Registration Act. they cut a deal on the legislature to say, okay, we're going to allow people to come off the registry for CSC4 early, and we're not going to let them have it expunged. Previously, they had a CSC4 expunged from the criminal record. So that was a compromise that was made when the Michigan Sex Offender Registry Act was modified back in 2014. And then I think that covers all of them. Sexual use of material involving a minor child, using a computer to solicit a minor. So there's a lot of these categories that we're looking at. Vulnerable individuals, abuse of children and things like that. Repeat offenders for drunk driving, serious traffic offenses, that sort of thing are all considered to be, not expungable. This could be tweaked. I want to be honest. So much. The only addition that was added, like I said a couple of years ago, was allowing the UI to come off. That took a lot of hand wringing in the legislature with the governor to make that deal. But because it was such a dramatic change in the law after decades of nothing, I don't think this will be revised in any significant way for quite a while. It's kind of my read on how things are going. So this list was unlikely to change in terms of what will not be qualified to set aside. Again, that other one is if you have more than 3 felony convictions, you're considered to be a supermax criminal. That's not all turn out because it's too far gone, so nothing come off at all. No misdemeanors and no felonies.
Let's see. Oh, it's the speaker. I didn't know what that sound was. Are there any questions that you hear a lot that you think you should probably tell people about?
No, I don't. It's really. I think. I want to be straight honest that I think a lot of this can be by yourself.
Mm-hmm.
But, I think especially the low levels. I think especially the low levels.
If enough time has passed,
If enough time has passed,
it's not something
not something that I'm going to say you need to go higher or lower.
I'll
I'll tell you that the hard one, because there are. I had a guy who had a 4th-degree CSC that he committed prior to 2015. That was the one that the judge recognized. So I want him to go have a psychosexual assessment done because of the nature of that offense. But things like retail fraud and things like that. I think you're getting into asking to have felony set aside, or if it's only been a short period of time. Probably what I hear a lot of is when am I eligible? When can this come off? And for some folks, I hear, when I talk to them and I get their criminal background, I say, you're not eligible yet, you'll be eligible here. But just because that's when you're eligible, it's not an entitlement. And I think that's the key. Some of these guys have had guys that they could not find their records because they committed them in the 70s before they had the system over there.
Right.
That they got, right.
So they don't
even know where this thing is. They got to recreate the file, set it aside. It's on the FBI file. It's preventing this guy from being able to buy a gun. But the hearing itself is a no-brainer. For somebody, 75-year-old man who did this when he was in his 20s,
it hasn't done anything since or
minor things.
But if you're just
coming out of a fire, you're at 5 years in a day from a serious misdemeanor. I think that and you really want to be curious. That's when you really could benefit from having a lawyer because it's not an automatic thing. They're really going to scrutinize whether or not enough time has passed that would warrant showing that you've truly changed your ways.
So I
So,
think that's probably the best
I
advice.
think that's probably the
Not
best
go in
advice
thinking
is to
this
not
is
go in thinking that this
entitlement.
is an
There still is
entitlement.
procedure.
There still
Yes.
is procedure.
All of the
Yes,
judges that I have
all of the
been-
judges that I have been in front of,
most of them,
most of them,
just a matter of
it's just
checking
a matter of
boxes.
checking the box and moving forward.
But the ones that they
Ones that
scrutinize
scrutinize
have been the
have been
ones that
like
morally or seriously
concerned
concerned
somebody
somebody
could
could
get
get hurt,
hurt,
or could get
could
hurt,
get hurt,
or it
or it
feels
feels
it happened
it
at
happened
that
at
point.
that point.
Right.
You know what I'm saying?
I'm saying.
And so
So
it doesn't mean
doesn't
you're not
mean
going
you're
to
not
make
gonna
it.
make
It just means
just
I
means
think
that
you really could
benefit from having somebody
who
knows
knows, what the judge
is going to want here or not here,
putting it in a way
and delivering it in such a way
that
that you
won't
won't
lose and then have to wait
have to
another
wait
3
for
years
years
before you try to
Yeah.
you know.
I mean,
I mean,
the lady that I lost,
with, and it was so
the
unfortunate.
lady that I
The
lost,
lady that I lost with,
all she wanted
all
to be
she
able
wanted
to
to be able to do,
do,
she had some kind of a child abuse or domestic violence. I forget what it was.
all she wanted
All
to
she
be able
wanted to
to
be
do,
able to do was to accompany her kids on a field trip.
and the
And the
judge,
judge,
because she said
because
what
she
she
said what she said,
said you
said
have
you have not learned your lesson.
you are
not entitled to it.
And
now,
the kids are
in elementary school.
they're going to be
They're
in
going to be in middle school,
if not
if not high school.
high
They're not going on field trips with mom anymore.
you know.
You know,
So it's not
something.
it's not something
to play loose and fast with. If you use your common sense to say, yeah, this is not something that a judge would just
wipe
wipe
away
away
because I stayed out of trouble.
Right.
because I stayed out of trouble.
Yeah, that makes sense. Let's see. Looks like we don't have any other questions. If someone was looking for your services, how can they find you?
So,
I am located right across the street from the courthouse
St.
in St. Joe, 800 Court Street.
Peter J. Johnson is my
Peter
father.
J. Johnson is my father. He's got his practice. He's been there
Quite a long time.
for quite a long
I'm still
time.
in there with him, but
I'm
I
still
got
in there
my
with him, but I've got my own name.
So I'm located there.
So I'm located there, right across from me.
Come and see me.
Come and see me. There's
Information will be
my
on the
information will be on the
Here as
slideshow.
well.
Here as
Email
well. Email me.
Call.
Give me a call.
I mean, honestly,
This is what I went to law school for.
I do.
I don't think I said what my areas of
My
practice.
biggest area.
My
of
biggest
practice
area of practice is family
Talk
law.
about here.
Talk about here and
The
over the other sessions we got coming up in the next few months.
But I do family law. I do
family law. I do mediation and family law.
But then I do these other.
But then I do
things
these other things that I consider to be
I like to
restorative.
help
I
people.
like to help people get their lives back on track.
Help people get their criminal
Help people get
records.
their criminal records
Help
cleared.
people
Help people
get their driver's
get
license.
their driver's license
Reinstated.
reinstated.
I help people.
I help people
with
with
planning.
estate planning.
We're going to talk about all of this
talk about
stuff
all of this stuff
here in this
here
speaker
in this
series.
speaker series over the next few months.
So honestly,
And I
offer free
offer
consults
free consults on the phone, and I'll go longer than I probably should.
because I want
Because I want
people
people
to get the information
to
that they need to
make
make
they
the
need so
decision.
they can make the
It's going to
decision.
best suit them.
It's
There's no
gonna best
reason
suit
why
them. There's no reason why this stuff
it's
needs to be under lock and key. You know?
And again, I'm not the only one out there
I'm not
doing
the only one out there doing it.
Great service.
Great service.
the self-help legal center.
Self-help legal center, second floor, Marion County, outstanding.
Those ladies all the time.
All the time.
They're great.
They're-
Michigan Legal Help.
Michigan will help.
That I will say
These are every time we do
because
they,
the state of Michigan
passed the Justice Campaign.
a lot
A lot of money.
set up
It's
a really
user-friendly website.
People
So that
not only
people not only go to get the forms they need.
It's very
It's
easy.
very easy to navigate.
And
You also have the instructions to go along with it on how to fill it out, where to go to file it, what you need to pay.
Whether you're on the
suing
side
side
or
or
on
on
the
being sued side,
and
you know,
it's just a great resource that a lot of people older than me
and
smarter
smarter than me
put together
to make it possible so that
anybody
can get this information.
But
But
sometimes
sometimes it helps to have somebody
to
talk to you specifically about your situation.
So
So
honestly,
honestly, please
call me,
stop by,
shoot
shoot me an
email.
email. I'm happy to chat with you about this issue.
So, as you mentioned, and we mentioned in the beginning, we'll be doing, this is just the first part of a 7-part series. So what do we have next?
All right, so coming up here, this is what's on our calendar. We're gonna be doing this on the third Thursday of the month with the exception of Christmas holiday time. Coming up next Thursday, October 17th, we're going to talk about restoring your driver's license. How to get your Michigan driving privileges restored. What's the difference between my license is revoked versus my license is suspended, or I live out of state, but I can't get a license here because Michigan has a hole in my license. So we're going to talk about that. On the 21st of November, which is not Thanksgiving, Thanksgiving is next week, we're going to talk about estate planning. So simple estates, wills, powers of attorney, healthcare directives, including end of life DNRs, and people that do not resuscitate orders. We're also going to talk about Ladybird deeds, which is an amazing thing in Michigan, one of a handful of states that does Ladybird deeds, which keeps your home out of probate. Simple to do, save a lot of money, a lot of time for your loved ones when you're gone. Starting in the new year, January 16th, we're going to talk about custody and parenting time. Probably a lot of people know what those terms mean, but what's the difference? What does that mean? And how to get custody, how to file for custody, parenting time, different options there. I also, the next month, in the full part, talk about child support, because child support really is an entity of itself. What does it mean? I'm obligated to pay for it. I'm not receiving the support I'm supposed to be receiving. What is the front of the court? What do they do? The following month in March, we're going to talk about paternity. So paternity is if you or someone you know has not established paternity yet, but is seeking to establish paternity, which would then allow you to move forward with custody, parenting, and child support. How do we go about doing that? Another big area of paternity is revocation of paternity. Let's say you believe that this child is yours when another father's name is on the birth certificate. How do I get in, or how do I file to at least say I want to try and prove that I'm this child's father? There's limits on how they can do that, how to do that, so we're going to talk about that then. And then finally, at the end of the series, now, April 17th, we're going to talk about guardianships. So I do a lot of probate court work, which include minor guardianships. If mom or dad are deceased, unavailable, dealing with mental health or drug issues, how do I file for guardianship for minor? We can also talk about legally incapacitated persons. Those are people who are generally older, that or have serious accident, traumatic brain injury, and need a guardianship. And then there's also developmentally disabled individuals. Those are people who have maybe severe autism or some kind of a disability that they're born with. They've now grown to be an adult, and they're going to continue to need guardianship going forward in their adult years. We're going to talk about all of those pieces. April 17th.
All right. So, you have anything else you need the people to know?
I don't think so. I just appreciate the opportunity, and I hope this can be helpful. And I think we're going to be able to get this thing saved and recorded somewhere so you can access it. Share with family members and friends. Get this out to as many people who need this information, and give me a holler if I can help.
All right, so that's our time for today. If you look on screen, you'll see our flyer for the next expungement fair located at LMC. Huge thank you to Blair for doing this for us, to the Michigan Attorney General's Office, Safe and Just Michigan, Berrien Community Foundation, and Legal Aid of Western Michigan. Have a good night.
Take care.